And welcome to this week's edition of the Life and Legacy Show, sponsored by the Sechler Law Firm, where great families make great estate plans. We're looking out for your estate planning needs all the time. And here at the Sechler Law Firm, we are an education-based law firm, meaning we want to give you a whole bunch of information before you make these incredibly important decisions. You know, the stuff that we deal with around here, the questions that we get asked, the decisions we ask our clients to make are some of the most difficult decisions that you're going to have to make in your entire life. You know, how do I want to be cared for when I'm a senior, and where do I want to receive that care, and how are we going to pay for it? And when my time ultimately comes and I'm going to pass away, who do I want to manage my affairs? And are there any special circumstances I need to look out for? Are there any family members I need to plan for a little bit differently? You know, do we have any special needs issues? Do we have any drug addiction issues? Do we have any poor money management issues that we need to think about? And so, you know, these are pretty deep issues, and not everybody likes to think about this stuff. You know, we do this for a living around here, but I understand that in your day-to-day conversations, we're not talking about this stuff. But this seems to me to be the kind of stuff that keeps people awake at night, just wondering about how all their affairs are going to end up going when life throws a curveball. And so we do this radio show, and we do a bunch of educational events, and there's a bunch of content on our website because um, where life in the law interact is often a complicated intersection. And this government rule book that we have that dictates the answers to some of these questions itself is pretty darn complicated. And, you know, but the nicest thing about this is that a lot of the time the state's rule book, you know, the government's rule book will allow you to modify the game. You can write your own rule book if you take the time to understand these issues, and you take the time to sit down with us, and you take the time to understand just how some of these different things work, and some of how these tools work that can interact with the law, and really set your family up for success. And in today's episode, we're going to be talking about a few of those tools. We're going to be talking about trust today, and you know, one of the questions that we're increasingly getting in our office is the difference between a revocable trust and an irrevocable trust. I did a workshop just last week, and a lady asked me, "I thought trusts were just for rich people," you know, and no, it is true that rich people use trusts, but there's no law that says you have to be worth $5 million before you consider a trust. We do trusts for everyday folks, middle class folks, every week in our office. The question really comes down to, before we choose the tool, before we choose whether the will is the right tool, before we choose a beneficiary designation on a financial investment, before we choose some sort of a trust, the introduction question is, what are we trying to accomplish? You know, because if you ask me which is better, a revocable trust or an irrevocable trust, it's like asking me the question, which is better, a hammer or a screwdriver, right? It really depends on what you're trying to accomplish right now. And if you're trying to hammer a nail into a board, you want a hammer. If you're trying to fix a VCR and put the thing back together, a screwdriver is probably a better idea. And it just occurred to me that I said VCR, and there's a significant percentage of the people that are going to be hearing this that have no idea what a VCR is. But I think you get the analogy. So, you know, one of the points of confusion is between revocable trusts and irrevocable trusts, and this is confusing stuff. And sometimes, unfortunately, people get confused, and a confused mind just says no. And so people will start to research this stuff, and they'll start to try to understand this stuff, and then they'll get themselves kind of turned around, and they'll just say, you know what, I'm not doing anything because I don't really get it, and I don't want to make mistakes. And so that's why the education. So let's talk about what a trust is. And before we get into it, like, if you want to know more information about these subjects, you should come to one of our workshops. We're doing them almost weekly at this point, estate planning workshops. We have people into our office or into somewhere else in the community where we're talking about wills versus trust, revocable trust versus irrevocable trust, tax implications, long-term care implications, doing a deeper dive than what I'm going to do on this radio show. But if you're curious about this, you really ought to reach out to us and ask some questions of us. The phone number is 724-546-4227. Again, 546-4227. And, at the workshop, we go through all these different things, and you can find out more about the workshop. I'm sorry, you can find out more about the workshop at SechlerLawFirm.com. That's SECHLER lawfirm.com. All right, so let's talk about trust. Revocable trust or an irrevocable trust. And think of a trust sort of like you might think about a company. It's not exactly the same, but it's analogous to like thinking about a company. So think about so my law firm is a company. The Sechler Law Firm is a company, right? Now I'm in control of it, but it owns the computer I'm staring at, and it owns the desk that I'm sitting at, and it owns its own thing. It's its own legal entity. And when you create a trust, the only place a trust exists physically is the paperwork that we use to draw it up. So I write a trust agreement. My clients sign the trust agreement, and we just gave birth to this new legal entity, this agreement. And we can then render assets subject to that agreement by changing ownership. So what you do is you say, I'm changing ownership of my house to the trust. I'm changing ownership of my investment account to the trust. And now those assets are now subject to this trust agreement. It's kind of like they're owned by the trust. Not technically, but it's kind of like they're owned by the trust, right? And so I like to use, like, picture in your mind's eye a radio flyer. And for those people that are watching this on the YouTube channel, I happen to have a little radio flyer. But you think about the trust like a little radio flyer red wagon, right? And then the idea is there's three people involved. The person who creates their stuff, creates the trust, and then puts their stuff into the trust, changes ownership of the stuff, puts their house into the trust, and so I'm putting an object into my little red wagon, right? So now the little red wagon, the trust, owns that asset. The person in control, the person who has the handle to the wagon, is called the trustee. That's the person who makes the decisions. And then the people who can use the stuff that the trust owns, be it a house or some money, those people are called beneficiaries. So in a trust arrangement, there's three types of people. The grantor is the person who creates it, and they grant ownership of their stuff to the trust. The trustee is the person in control. The beneficiaries are the people who have access. Now, in some trusts, I want to be all three people. I'm going to create a trust. I'm going to put my home into the trust. I'm going to put some money into the trust. I'm going to continue to be the trustee, and I'm going to be the beneficiary. I'm going to use those dollars. I'm going to use that house. I'm going to sleep in that house. I'm going to do all the things that I normally would do, right? We create the trust, and things kind of go back to normal. Life goes back to normal. So why would someone put their assets into a trust? Well, with a revocable trust, the primary reason most people consider using a revocable living trust is about avoiding the probate process. See, understand that this trust is sort of an alternative to a will, right? And most people understand the concept of a will. It's a document that says when I pass away, here's where you send the money, here's where you send the house, here's where you send the stuff, and here's the executor, right? Well, a trust does that. But the difference between a will and a trust is if you pass away and your assets go through a will, they have to go through this process called probate, which is a judge managed administrative process to get this stuff to the kids. It's time consuming. Most estates take anywhere around 14 months, maybe a little bit longer, more or less 14 months. And it can be expensive. Lawyers charge hefty legal fees to help you through the probate process, because the fact is it's kind of a pain in the neck process, and we don't really want to do it either. And so, it's a cumbersome thing, and if you have been the executor of a will, especially the executor of an estate that didn't go so well, then you know what I'm talking about. It's just there's all these legal hoops you have to jump through, and there's this sort of drug out timeline, and every once in a while you have a judge that sort of imparts their own opinion. I recently was involved in an estate, and the estate, the will left only a relatively small amount of money to some young kids. It was like $7,000 to the grandkids or something like that. And what we tried to do was just simply create what's called a Uniform Transfers to Minors Act account, which is essentially put the money in the account, and then the parents can be in charge of the account until they turn legal age of majority. But the judge wouldn't let us do it. The judge had the experience, and I don't doubt that he had the experience, of people being put in charge of like a nephew's money and then using it for their own good. And then when the nephew turns 18 or 21 and had access to the money, it's not there anymore. And so with these kids that were only getting about $7,000, the judge required us to set up a sequestered account, which means we couldn't access the money for this for these kids throughout their adolescent years, their young years. We couldn't access the money without a court order, which for $7,000, getting into court to access the money is going to cost a third of the money. And it just was an ugly situation. It was a situation where, in my opinion, we didn't probably really need to go that far to protect $7,000. But that's an example of what happens when you get into the court system, and the judge is ultimately in charge. It's the judge's call on a lot of these things, and so people talk about avoiding probate, and the best way to do it, in my opinion, is we don't use a will to manage someone's estate. We use a trust. We put the stuff into the trust because a trust is administered around a lawyer's conference table rather than in the courthouse. And it tends to save some headache, and it tends to save some expense, and it tends to save from having a third party have an opinion about what's going on. It tends to keep the kids from fighting as much. And it tends to be cheaper to administer. And so, from where I sit, living in this world and doing this stuff all day, there's nothing wrong with wills. But if someone were to ask me, would you rather have your stuff in a will or a trust? Would you rather administer a will or a trust? I just think trusts are better tools. I just think it's a smoother way to keep some things private in a family matter and keep the administrative burden down when you pass away. So revocable living trust, generally used. Probate avoidance, and they come in handy for some other reasons. Revocable trusts are handy in second marriages where we have like specific goals. Second marriage, I have kids, she has kids, and if I pass away first, I want to take it. I want to provide for my spouse, but when she passes away, I want that money to go to my kids. So second marriage type situations, blended families. Revocable trust can be handy tools in a number of different circumstances, but the primary reason people talk about them is the probate avoidance. Okay, so that's a revocable living trust. You create the trust, you maintain total control, and you maintain total access, and then when you ultimately pass away, we skip the courthouse on the way out. There are also irrevocable trusts. So an irrevocable trust is a document that once you've signed this agreement, you put the stuff in it, you can't revoke that document anymore, meaning you can't just tear up the paperwork and own the thing again. It's an irrevocable trust, not revocable. Now, the word irrevocable scares the heck out of people, okay? And I want to just talk about that for a second because people hear the word irrevocable and they think the word permanent. But I'm going to show you as we go through an example that there's lots of things about an irrevocable trust that may not be permanent. You can maintain a fair amount of flexibility with an irrevocable trust, and they're really not as permanent as the word implies. And if you're listening to this, if you're watching this, and you find this information helpful, you want to learn more about whether one of these tools is right for you. Maybe you've still got a will from when the kids were little, and now you're retirement age or pushing retirement age, and it's time to update this stuff. You're wanting to know, should I use a will? Should I use a revocable living trust? Should I use an irrevocable trust? I suggest you check out the materials we have at sechlerlawfirm.com, SECHLER lawfirm.com. And at the website, you can schedule to come to one of our upcoming workshops. So the workshops are great. They really are. We get very positive feedback. We ask people to rank the workshop on a scale of 1 to 5, and we're averaging like a 4.7 for the last couple of years. People find real value in coming to the workshop because we answer your questions. We explain this stuff in a way that it's easy to understand. We talk about taxes. We talk about long-term care expenses. We talk about asset protection. We talk about the things that most people don't sit around thinking about, but they probably should, because these are some of the most important decisions in your life. And how are you going to make that decision without first having some education? And so I suggest you check it out. I think they're good. We're friendly people. Get you a good fresh made cookie and a cup of coffee, and get you some good education. But moving back to talking about irrevocable trust, not revocable trust. So again, remember, with a revocable trust, we're talking about the little red wagon as an analogy. So I'm going to bring the thing back in here if you're watching on YouTube. or if you're listening on the radio, you can find this on our YouTube channel. But the idea is, okay, I'm going to put my stuff, I'm going to make my house subject to the trust agreement. I'm going to change ownership of my house, make it subject to the trust agreement. Now the trust owns the house. Then what we do with an irrevocable trust, in most situations, you put a lid on it, right? I can no longer have that asset anymore. I've given up access to my own money. Now, keep in mind, what we're really doing with these documents is managing control and access. Who's in control of me and my things? Who's got access to me and my things? And so with an irrevocable trust, generally speaking, I'm giving up access to my money. Now, there are lots of types of irrevocable trusts. Some irrevocable trusts, you also give up total control, right? I could put the asset in a trust. I name my kid or a professional as a trustee on the trust. I'm no longer a beneficiary. It's really permanently in trust for someone else. With other types of trusts, and trusts that I think are more likely to be used in an estate plan for, middle class, upper middle class families, you can maintain control. You can stay as a trustee. You can change beneficiaries of the trust. You can change lots of things. But the one thing that you give up in the trust is the ability to own the money again. If you put your house in the trust, if you put money in the trust, you cannot own that thing again. And so why in the world would a lawyer recommend to their client to give up access, give up the right to own their own money again, the right to use their own money again for themselves from the trust? And the answer is because by giving up access to the money, I can't get it anymore, but neither can they. Neither can the government rules. Neither can maybe taxes could be a concern. But the most important thing, I think, in a lot of families is long-term care expenses. By putting my assets into an irrevocable trust, I can maintain control over those assets, but I give up access to them. And in doing so, I can protect those dollars. I can protect that house from the nursing home, or more accurately, the harsh government rules that require you to go broke if you need a nursing home. But I can put my assets into a trust and protect it from that part of the state's rule book, because, it seems to me that most people don't go their whole lives saving money, building a nest egg. And the idea is we got this legacy, and I'm going to probably, have my money outlive me. So there's going to be some leftovers. And what I ultimately want to occur with those leftovers is I want the dollars to get to the benefit of my kids, my family, my niece, my nephew, whoever that is for you. I don't want to lose the money to the government's rule book or to taxes or to the nursing home, or these other issues that can affect seniors. And so we use, in the Sechler law firm, we use a fair amount of irrevocable trust. We call them asset protection trusts. We put the assets in. Our clients give up access to the money, but they maintain control over the money. And in doing so, we protect the money, the house, the savings from nursing home expenses. Now, wait a second, though. What happens if I need the money? I put the thing in the trust, right? I put my house in the trust. I put my money in my trust. There's usually three questions that we get. And the first is, how could I ever get the money again? And the answer is you can't. You're giving up access to the money because you're not a beneficiary of this trust. But the trust has beneficiaries, and that would typically be your children. So if you live in a situation where you trust your children, you could put assets into a trust. The children are the beneficiaries of the trust, and we can write money to a check from the trust to the kids, right? And the kids, it turns out, still love their parents. And if you needed support, they would help you, right? Now, this is not prearranged. Like, our clients' kids don't even know that we're doing this to set it up. It's not like something where it's a conspiracy and it's a sham. We're actually setting up a trust with the leftovers, the assets that we think are going to be left around. Most families are not going to sell their house to live on the money, right? They're just not. They're going to own that house. They're going to own another house. And so if the house is worth $250,000, why not put it into a trust that if I ever end up in the nursing home, they can't have it? Like, I'm not going to access that money. So we set up these irrevocable trusts for folks. 95% of the time, the families never access the money in the trust. But it's important to know that you could, because sometimes it rains, and we're talking about protecting the rainy day fund, right? And so if the family absolutely needed to get to the money, you write a check to the kids, and then the kids still love you. And, this to me is just practical planning. The terms of the trust by its terms say, I, as the creator of the trust, can never have this money again. And, it's not any different than what families have been doing for a long, long time. Families have been putting assets into their kids' names, right? It's almost like there's a bell that goes off when somebody turns 75, and they go and they transfer and they put their house in their kid's name, and they're doing this because they're concerned about protecting it from like taxes or the probate courts or the nursing home. Um, and it can work for some of that, but oftentimes it's a mistake, because as soon as you put your house into your kids' names, you've just given up control. If I put my house in my son's name and then my son goes through a divorce, where am I in that situation? What happens if my son dies before me, right? What's his will say? Everything to his wife. So now I'm living in a house owned by my former daughter-in-law. Right? What happens when she remarries? Where am I? Right. And so, when I'm working with clients, I am a big proponent of maintaining control. And this outright gifting stuff requires people to give up control, which is frequently a big mistake. And so trust can accomplish the same thing, right? And trust can be used to give up access, protect the assets from the nursing home without giving up control. You're not subjecting the house to your kid's divorce. You're not subjecting your house to your kid's poor spending habits. You're not subjecting your house to your kid passing away before you. If any of that nasty stuff happens, that's unfortunate, but your house is not subject to those issues. And this to me just makes a ton of sense. The second thing that people want to know about is taxes, right? Okay, so I understand. I could put the house in a trust. If we as a family ever needed to access the money, if my kid ever needed the money, could distribute it to the kid. My kid could provide for me. Fine. What are the tax ramifications of this? Well, see, the trust works because from asset protection, in particular for nursing home law, you have to give up access to your money. If you cannot get the money, neither can the nursing home, neither can the government's rule books. That the tax man largely, though, is concerned about control, right? If I put my assets into a trust and I maintain control of the assets in the trust, the IRS continues to tax me on the money anyhow. And so in the IRS's eyes, by putting the house in the type of trust that I've been discussing on today's show, the assets would stay in my social security number. So it doesn't become this really complicated, headachy thing to administer. If there's a 1099, if there's income, if I put money in the trust and the bank issues a 1099 at the end of the year, that's on my personal 1040. So it's really not all that complicated. And then there's one more question people want to know the answer to. And if I put my house in a trust, could I ever sell that house? And the answer is yes. But if you sell that house, then the money, the sales proceeds, belong to the trust. The trust owned the house. So if we sell the house, the trust gets the money, and then the trust can buy your next house, right? And so the ownership just never leaves the money just never leaves the ownership of the house. And so, look, this has been a little bit in the weeds, I suspect, for some people. It's been complicated, but this is the question that we get the most. Like, okay, Tim, I like the idea of a trust. I like the idea of avoiding probate. I like the idea of maintaining control. So is it a revocable trust or is it an irrevocable trust? And if your concern is that you would like to protect assets from long-term care expenses, the nursing home, then an irrevocable trust is the only one that does it. And you ought to learn more about how these things work. And you can learn more about how these things work by coming to one of our upcoming workshops, which you can register for at sechlerlawfirm.com, SECHLER lawfirm.com. We're located in Cranberry, just off the interstate, really accessible from anywhere in Western Pennsylvania. And we do a nice job with these things. People rate them really highly. People tell us that they learn a ton of information by coming to the workshop. And when you come to the workshop, we're going to talk about wills and trusts. We're going to talk about power of attorney documents. We're going to talk about taxes. We're going to talk about nursing home asset protection. We're going to talk about your retirement accounts and how to properly plan for those. We're also going to talk about an issue that a lot of people tend to be asking me about is what happens if I leave money to my kid and my kid goes to a divorce? Can we protect my kid's inheritance from that issue? And so all of these things, which are really difficult to talk about and really difficult to think about, but really necessary to make decisions on, we handle them in the workshop, and it's a great use of your time. And if you come to the workshop, we then offer you a free consultation to start doing some goal setting. Okay, tell me about your family. Tell me about your finances. Is there anything that you know you want to accomplish with your estate plan? And then we're going to do, have you thought about this? Have you thought about that? Have you thought about this? And then based on this process of education first, then doing some goal setting, then and only then are we going to say to you, okay, it sounds like what you can accomplish, what based on your goals, you can do this with a will. Based on your goals, you should use a revocable living trust. You could use an irrevocable trust. Frankly, I don't care what you use. What I do care about is you're taking the time to understand these things. And I hope you join us at one of the upcoming workshops so you can learn about this. Get your free consultation. Okay. Sechlerlawfirm.com, Sechler lawfirm.com. I thank you for listening this week. Don't make any decisions based on what you heard on this radio show. It's a radio show. If you like legal advice, give us a shout. Have a great week.